Without further ado, we will move to our topic of this afternoon, accommodation challenges and solutions. The makeup of the 21st century workforce, as we are all aware, carries with it wonderful opportunities, but also considerable challenges. We have, for instance, a multitude of generations in the workplace. We've got the Gen Ys, Gen X's, baby boomers. We still have, of course, the silent generation, those who were born in the 1925 to 1945 time frame. And we are starting to see the Gen Zs, born in 2000 and thereafter. Each of these generations come with their own histories, styles of communications and approaches to projects and job responsibilities, their own perspectives, and their own expectations. Our workforce is, in addition, multilingual and multicultural. More and more new Americans are entering the workforce with their own distinct perspectives, backgrounds, languages, and their own approaches to workplace communications, job responsibilities, and of course their own expectations. In addition, we have another factor in the 21st century workforce. A number of mental health professionals are opining these days that the uncertainty in the nation and the world at large, socially, politically, and environmentally, has already and will continue to affect individuals, even if they themselves are not directly involved in the unrest and the turmoil. We don't need to look very far for examples of this. The natural disasters we have seen in the country and the world, even in the last 6 months, are a prominent example. The violent tragedies in the U.S. and abroad, and the political and social disputes we see at every turn. Employees are said to carry these things into the workplace with them and be affected by them during their workday. In addition, employees walk into our workplaces with any number of stresses due to personal issues, family, relationship issues, mental or physical health challenges, drug and alcohol use, prescription drug and alcohol use and abuse. These realities for the 21st century workplace play out in various ways. They can cause irritable behavior, impatient behavior, unprofessional behavior, and misconduct. And they can also manifest, of course, in physical and mental impairments and disabilities that impact work performance and the work environment. Ultimately, these realities can and do evolve from a legal perspective into situations that require work accommodations under the Federal Americans with Disabilities Act and the state and local human rights laws. There are a number of statistics I would like to just point out briefly that are relevant to our conversation today, that can put even more context to our 21st century workforce. The Social Security Administration reported in 2015 that 1 in 4 workers will be disabled before retirement. The National Institute of Mental Health in the same year reported that 17.9% of U.S. adults have mental health issues. The National Institute on Alcohol Abuse and Alcoholism had some very interesting statistics, which surprised me actually. They reported that 26.9% of the U.S. adults surveyed had engaged in binge drinking in the previous 30 days, and 7% had engaged in heavy drinking. Similarly, the National Institute of Drug Abuse reported that 9.4% of the adults surveyed had engaged in the consumption of illegal drugs in the previous 30 days. The U.S. Department of Health and Human Services puts out a comprehensive hundreds and hundreds of page report every year. And their report in 2016 had an interesting statistic. It indicated that 49% of U.S. adults in the age groups of 45 to 64 took between 1 and 4 prescription drugs in the previous 30 days. As relates to the aging workforce, there are some interesting numbers. The Bureau of Labor Statistics reported in May of 2017 that 22.4% of the workforce was age 55 and older, and that it is expected by the year 2024 that 24.8% of the workforce will be age 55 and older. The Gallup poll indicates that 74% of workers indicate that they will be continuing to work past what they would consider normal retirement age, and 11% of those plan to work full-time, and 63% plan to work part-time. So these all factor into the realities of the 21st century workforce. This afternoon, I thought it would be helpful to move beyond the fundamentals of accommodation and discuss a number of the more difficult accommodation situations that our clients are facing. I'm going to cover 4 specific areas in our time today: mental health, drugs and alcohol, the aging workforce, and the special case of pregnancy. And in doing so, I'm going to outline approaches for addressing each scenario. Just a bit of a word of caution before we jump in. The 4 areas that we're discussing this afternoon are particularly tricky and therefore necessarily carry with them a high degree of legal risk. Thus, especially in these areas, it is my advice that employers involve legal counsel at some point in the process to assist with mapping out a path that is going to achieve a resolution for you from a business perspective with the least amount of legal risk. My goal actually in our time today is to outline strategies for addressing some difficult scenarios in these areas, with the goal of illustrating that even in the most difficult situations, we can and do have paths forward towards resolution. So going to our first scenario, which is a mental health scenario, we have mental health conditions are likely the first and foremost on everyone's list of difficult accommodation challenges. Often the mental health issues are thought of as a hidden disability because physical or physical health manifestations are not always present or apparent, and it's difficult to even identify behavioral manifestations of them. In our scenario, we have Mark. Each of the scenarios I'm going to be talking about this afternoon are actually taken from real-life situations that have crossed my desk in the last year or so. And so in this scenario, we have Mark. He's a salesperson. He has had a pattern lately of being combative with his supervisor. He's irritable, defensive when the supervisor raises work issues. He has a confrontational style. He tends to be short-tempered and rude. The HR department has had employee complaints about him over the years. They'll talk to him about his behavior informally. He gets better for a little bit and then falls back into old patterns. The issues have not been addressed on a formal level. What are the business considerations here? There are always business considerations in each of these scenarios. Mark is a long-term employee. He has been very valuable to the organization. He has very good sales figures. He is also a close friend of some influential officers in the company that support him. And he is viewed as not being easy to replace in the job market. The department also is extremely busy. So what is our trigger to this situation? It seems like with these situations that haven't been addressed with employees and have become a pattern of behavior or a pattern of misconduct, there's always a trigger to what makes a company actually address the issues. So here our trigger is that there's a new, younger female employee who complains to HR. She's a customer service rep, and she complains that Mark was verbally abusive to her and cursed at her. She says that she is becoming afraid of him. She also suggests that he is treating women much more harshly than men. So if you're the HR professional to whom this complaint comes, you do your job, you investigate, you of course gather information from the customer service rep who is complaining. In this situation, there was another witness to some of the behavior. A coworker of the customer service rep, you interview her. She confirms what the customer service rep reports, and she also reports her own historical experiences with Mark, saying that he has treated her similarly. Mark admits to the behavior, but has a slightly different story about what happened. So there are two scenarios. There are a number of scenarios that can develop from this factual situation, but I'm going to address two of them. In scenario number one, when the HR professional meets with Mark, he does not disclose that he has a mental health condition, and he does not really make any excuses or identify anything that's causing his behavior. He simply has a slightly different story about what happened. The HR professional, or the management person that was doing this investigation, however, suspects that there is an underlying mental health issue because of their observations of his behavior over a number of years. But again, Mark has never raised this as an issue to anyone. In these circumstances, you likely would move forward and treat this as a performance issue. There's some circumstances where you might not, but in most circumstances here you would. And so you would go forward and treat this as a performance issue. You would complete your investigation, meet with Mark together. An outline of a process might be as follows. You would meet with Mark together with his manager so that Mark knows that this is a serious situation and it has to be addressed. You would coach him on appropriate workplace behavior. You would identify for him what in his behavior and his interactions with the customer service rep was inappropriate, and you would make clear what the expectations are going forward. You would confirm all of this in a memorandum or other written documentation that is provided to him in the meeting, at the end of the meeting, with some real specific direction to him. For instance, you will not raise your voice. You will not use expletives. You are expected to behave in a professional and respectful manner. And you also, in that writing or memorandum, make clear what the consequences of the failure to comply or the reoccurrence of this kind of behavior. Disciplinary action up to and including termination. You would then follow up with the customer service rep and also the coworker, thank them for bringing the concerns to your attention, let them know that Mark had been coached and that they should bring any further issues to your attention, and you will address them. You also want to check in with them, maybe at the 1 to 3 month mark, and maybe again at another 1 to 3 month mark, to make sure there are no continuing issues. If there are further occurrences, you investigate, you follow the same process. Investigate, document, follow up with Mark and those complaining, and provide escalating consequences. So if in this scenario number one, you eventually get to the point where Mark hasn't turned his behavior around, you've got decent documentation over a period of months of reoccurrences and informing him of consequences and expectations, you terminate his employment. So then you get a letter from an attorney for Mark claiming that he has been subject to disability discrimination and the company has failed to accommodate his mental health disability, which is now disclosed in the attorney's letter. However, in our situation, you had no knowledge or notice that Mark had any mental health issue. He had not brought that up to anyone, to your knowledge. And the company is not obligated under federal, state, or any other law known in the U.S. to reasonably accommodate a situation that they are not aware of. So that's scenario number two. Number one, let's move to a second scenario that might arise in our factual circumstance. So in this scenario, Mark discloses to you during your meeting with him, during your investigation, that he is having significant issues at home, that his wife has encouraged him to see a professional, that his physician referred him to a psychologist, and he is now being treated for depression. He tells you that he believes the depression is affecting his work and that the psychologist has been trying different medications in connection with his psychiatrist to determine what might work in his situation. And Mark tells you that he thinks there are side effects to this. So now we are in a completely different arena. Mark has disclosed a disability and the potential need for a work accommodation. The employer has the obligation under the federal law, the Federal Americans with Disabilities Act, and state human rights laws, to engage in an interactive process to determine whether there is a reasonable accommodation that can allow Mark to meet the essential functions of his job. Do you forget about your investigation? No, you do not. You just put it on hold so we can get our arms around the ADA situation. There are a number of sources of information for our interactive process. Of course, Mark, and he's already provided us with a good deal of information on what he thinks the issues are. His mental health provider or health provider is another source of information, and we always have in our back pocket, as long as your policies allow it, to have an independent assessment done down the road if what is being sent to us by the provider is not helpful or responsive. You need to, of course, be aware of what your policies are, and to have in the back of your mind that the FMLA, Family Medical Leave Act, may come into play here during the ADA process. We also are putting on hold the performance and workplace behavior issue. So when we are in the ADA mode, the interactive process mode, and that's where we are with Mark at this juncture, I refer to it as a process-based approach. So we need to engage in a process here. And the process is often the same no matter what kind of disability you're dealing with. So what do we do? So we've already met with Mark to obtain the initial, or at least he's disclosed to us in the meeting, the initial information. So what do? We need to meet with Mark again and explain to him that we need to obtain information from his treating provider as to the nature of the health or other condition that may be affecting his work performance or behavior, as to any restrictions that he may be under, work restrictions, and as to any recommended accommodations that his provider may have. In doing this, you should be using documentation that has at least been vetted by your counsel at one point, if not prepared by your counsel, because the wording of the communications to the employees in this area is critical. A type of communication might be a memo that you give to Mark at the end of the meeting, and including a document that he is to provide to his health or mental health provider, asking some particular questions about his current circumstances. When you receive the information back from the provider, you evaluate the responses with the understanding that courts and agencies will expect employers to make every effort to make a reasonable accommodation that will allow the individual to continue to perform the essential functions of their job. It's a pretty high threshold for employers. What are the potential outcomes here? The provider may say Mark needs a leave to address the mental health issues. He may need intermittent time off for counseling. He may need a reduced work schedule. You need to keep in mind, of course, your obligations to document any portion of that absence that is covered by the Family and Medical Leave Act or state Family and Medical Leave Act. Of course, you need to follow up on whether a portion of it is paid or unpaid under state and local law, and also under your policies. You, in the end, meet with Mark, talk to him about what accommodations will be made, and document that in some fashion to him. The easiest way to document an ADA process, in my opinion, is in a series of memos or emails to the employee. And of course, those need to be carefully worded. If you are at any point going to deny an accommodation, especially in the scenario we've just talked about with Mark, if you were going to tell him we cannot accommodate you, please do so only on advice of counsel. And do not forget that even in this scenario, we have a performance and misconduct issue to deal with. So once we've gotten our arms around the ADA process, documented what reasonable accommodations are going to be made, met with Mark on that, you have a separate meeting with Mark and go through the process that I outlined earlier under our first scenario. You meet with Mark together with his manager. You go through what was inappropriate in his behavior with the customer service rep and his behavior with the coworker. You outline in great detail what expectations are going forward. You document that in a memo to him and include in that memo the consequences for failure to meet the expectations, discipline up to and including termination. You meet with the customer service rep and the coworker, thank them for their bringing the concerns to your attention, and then let them know that Mark has been counseled and they should bring any future concerns to your attention and go through the rest of that process. If the behavior reoccurs, you continue to investigate, document, meet with Mark, meet with the employees complaining, etc. And ultimately, if the performance issues or the workplace behavior issues do not turn around, you will have, if you follow this process, two things. You will have excellent documentation of your ADA accommodation process and separate excellent documentation of the performance issues justifying the termination. Let's move to a different scenario, a drug and alcohol scenario. So the pattern here involves Sydney, general manager. He's been with the company for lots of years. He's had a series of unexplained absences. They've become a chronic issue over time, and they haven't really been addressed adequately. There are also some behavior patterns that are starting to emerge. There's some concern with his sometimes crass behavior, off-the-cuff remarks in the workplace. There's a concern over a combative style that appears from time to time. There have been rumors about excessive alcohol use outside of work in the presence of employees. None of this has been followed up on. Sydney appears to be sluggish often in the workplace. Folks have smelled alcohol on his breath from time to time, but they haven't been reported promptly. The situation has not been promptly reported and thus has not been followed up on. From a work performance issue perspective, there have been increased safety violations in the plant. Sydney is viewed as lax in enforcing safety rules, and there have been some accident investigations that have not been handled particularly correctly. The business considerations in this situation: he is a long-term employee. He is also a good friend of the former CEO who retired last year. The new CEO is impatient with the situation and has been frustrated with the levels of production, safety violations, and the handling of accidents. And the new CEO is coming down hard on the HR professionals to do something about it. So what's our trigger in this situation? Well, Sydney is working late one night, and so is the CEO, unfortunately for Sydney. And Sydney backs his car out in the parking lot and almost hits another car. The CEO witnesses this, detains Sydney, talks to him about it, and notices that Sydney has alcohol in his breath. The CEO calls the HR director at home. The HR director, just by chance, lives close to this facility and is able to drive over. Sydney admits to the HR director and the CEO that he has had 2 to 3 beers at lunch, that he was with clients and had them. So there are a number of scenarios that can evolve from this situation. I will again address a couple. You need to, of course, be aware in this situation of what your policies are, your drug and alcohol use policy, any other policies that would apply, and of course whether or not you have a drug and alcohol testing policy in this instance. So I'm going to talk about two scenarios that might come out of this situation. One is a scenario where you do not have a drug and alcohol testing policy in place, and the other is a scenario where you have a drug and alcohol testing policy in place. So first scenario, no drug and alcohol testing policy in place. Well, the first order of business in the parking lot is to make sure that Sydney arrives home safely and doesn't drive himself. So you arrange for a cab or other transportation for him home. You tell him that you're going to put him on a paid leave pending the company's review of the situation, and he's not to report for work until he hears from you. So one potential outcome right off the bat, it is possible, although risky, depending on your policies and your past practices, to terminate in this situation. He admitted that he was under the influence of alcohol at work. If you have a well-drafted policy that puts employees on notice, particularly of their requirement in this regard, this might be a consideration. I would not do this without obtaining advice of counsel, because the counsel will ask you a number of questions that would come into play in the scenario. But let's say that you're going to go down the more typical path in this scenario where you don't have a drug and alcohol testing policy. You're not going to terminate right away. So how do you proceed with this? You bring Mark in, bring Sydney in. I'm caught on Mark today. You bring Sydney in. You have ready to go for the meeting with Sydney a memorandum, or some people call it a return to work agreement, but the documentation that you're going to give to Sydney that tells him what the expectations are, what the problem is, what the expectations are going forward, and what is required for him to return to work. One of the key things in this memorandum or return to work agreement would be that he would obtain an assessment for a chemical dependency assessment from a licensed facility, and that he would follow the recommendations of that assessment. We would also work into that document a consent for certain information to be provided to the employer. You do not want all of the information for lots of different reasons. So this is a document that if you have not had it vetted by your counsel, you should. But the employer should have access to certain information in the process. So what are the potential outcomes here? One is, of course, that the assessment is that he needs to have some kind of treatment and he needs to have some time off to have the benefit of that treatment. In that regard, you want to make sure that your Family and Medical Leave Act paperwork is all in order, you're giving the proper notices and following your leave policies, and also making sure that if there is paid time off of any kind available to him, STD, et cetera, that is given to him. So what are some of the potential outcomes in this situation? Sydney could refuse to get the assessment, or he could go and get the assessment, refuse to do the treatment that's recommended, or he could not successfully complete the treatment. In all three of those scenarios, you would be looking to whether it's appropriate to terminate Sydney. Again, at this point, I would definitely, if you haven't previously in this process gotten advice of counsel, I would check in with counsel as to the appropriate steps to terminate, but that would be the typical outcome there. Another outcome is possibly that he would come back to work, meet all the requirements, and there would not be any further recurrence of these issues. That's all great. Another outcome might be he meets all the requirements, he returns to work, and he has a reoccurrence. So in that circumstance, your original memorandum will have said that if there are any future occurrences, and it'll be phrased correctly to give you lots of leeway in that regard, that he would be subject to immediate termination. So as long as you've got good information that he is at work under the influence, you would proceed down that path. The other piece in all of these scenarios, and I keep going back to it, is that, this individual in our scenario has a drug and or alcohol issue that is being addressed by the process we've spoken about. But there are also the performance issues and concerns. So while you are documenting appropriately your handling of the drug and alcohol issue, as we've discussed, you also should start to address and document the performance concerns, again, so that we have these two paths, two excellent, hopefully, pieces of documents that will justify a termination or other decision down the road if that's where we need to go. Scenario 2 would be where you've got a drug and alcohol testing policy. Now, I'm going to assume in this respect that you have a policy that is in conformance with federal law, but is also in conformance with state law in the state in which this employee is employed. If your drug and alcohol testing policy is very short, it is most likely not in conformance with federal and state and applicable state law. And if it has not been reviewed by counsel recently, there have been some changes in this area, and I would advise that you have counsel review it. But let's say that you've got a drug and alcohol testing policy that was appropriately issued and is in conformance with federal and state law. You would follow the policy. So back to the parking lot, you would make sure that there is safe transportation of Sydney to the facility where he is going to be tested. I am assuming that you have all the appropriate consent forms, etc. And then if your policy is well drafted, you simply follow your policy. If he refuses to test, the consequences under most policies are termination. If he does test positive, and in some states there are various bells and whistles that need to come into play after a positive test, after all of that is complied with, your policy will likely offer the opportunity to have a chemical dependency assessment and to get treatment for that. So at that point, you would go into the same process, the return to work agreement, et cetera, that we discussed in scenario number 1. Even if your policy does not allow the opportunity to have a chemical dependency assessment and treatment at this stage, I would check in with your counsel before you terminate, because there are some Americans with Disabilities Act implications depending on the circumstances. Your outcomes after a positive test and a successful return to work would be similar to the others we discussed, except that if there is a further reasonable suspicion that he is under the influence, he would again be tested under the policy, and most policies would indicate that there is termination at that stage. There are some potential action items that come out of these scenarios, and in the drug and alcohol scenario, you may well find if you didn't have a drug and alcohol testing policy in place, you might want to have a discussion about whether that is something that your workforce, that would be helpful to your workforce or not. I have clients that are all over the board on this issue, and for some clients it makes sense, and for others it absolutely does not. You'll also find when you work through one of these scenarios, particularly one of these difficult scenarios, that there are policies that you wish had been drafted differently that would have helped you. So in the scenario about the first scenario where we don't have a drug and alcohol testing policy, maybe we don't have a drug and alcohol use policy of any kind in the handbook, or maybe it's very weak as to what is required and what is prohibited. So that might be something you'd look at. And in this second scenario, of course, as with the others, do not forget about the performance issues. The individual had performance issues, and those need to be addressed outside of the whole drug and alcohol accommodation and testing circumstance if the person comes back to work. Let's talk about a scenario involving the aging workforce. These types of situations can be very emotionally charged for everyone involved, and I would bet if we were all in a room together, I would have a show of hands of quite a number of you that are either running into this right now or have run into this and how difficult it is. So in our aging workforce scenario, I'm going to use a professional employee example, but these principles could be used with an employee at any level. So our employee is Cecilia. She is an accountant, and she has been with an accounting firm for many years and been very successful there. She has started to show over the last several years a lack of attention to detail. She's had an increasing number of errors, and the explanation for those errors either has not held true in each situation or didn't quite make sense. She appears to be more absent-minded. She appears to not track totally when in meetings, work meetings. Her speech patterns have indicated to some people they've started to feel that she's not really at the top of her game anymore. She has had evidenced decreased participation in work projects and events and seems withdrawn. It's become somewhat of a chronic issue over a period of years, but it has not been addressed either formally or informally. The business considerations here have a little different twist to them. She is a long-term employee. Of course, she, like others, has valuable skills and contributions to the firm. She has a large number of important clients and has made a lot of money for the firm over the years. She also has deep long-term relationships and friendships with those folks in the firm, which makes sense. And the work demands here, just due to the nature of the work, are extraordinary. She also, because she is an accountant, has separate professional and ethical obligations. So what is the trigger in our situation? The trigger is one of the worst of all possible triggers. The accounting firm receives a complaint from a major client. So let's say that last evening, Cecilia was making a report to the board of a client on a recent audit. The next morning, the chair of the board calls the managing director of the firm, I'll just call him Tom, calls Tom and expresses his concern for Cecilia about what happened the night before, but also expresses, a business concern because, they have a business to run. He reports that Cecilia did not seem to understand at all points during the board meeting what was going on. She clearly had a draft report when she knew that the report was supposed to be in final form because she was presenting to the board that evening. And she had trouble answering questions on the report. The chair indicates to Tom that in the end, the board decided to convene the meeting for the next month. So what does the managing director do? He does what's absolutely appropriate. He finds Cecilia and meets with her and relays to her what the chair has relayed to him. Cecilia's reaction is that she was very tired, she was very stressed. She makes excuses. She says that, Tom, I will make this right. You know me, this is not like me. Tom asked her, do you need some time off, Cecilia? What's going on? Nothing, Tom, I'm just fine. It's Friday. I'm going to take the weekend and get some rest, and I will make this right. I guarantee you I will make this right. Tom says, okay, take care of yourself, get some rest, Cecilia. Over the weekend, he thinks, of course, more about this and his own observations of Cecilia over a number of years, and he speaks with other senior management by phone over the weekend. Each of them raises similar concerns about Cecilia and what they've observed, and one raises concerns in terms of he has a sister that has been suffering from significant memory loss, and he sees a lot of the same things in Cecilia that he sadly sees in his sister. So the concerns are considerable, and the senior management is left with some decisions. So I'm going to jump to, in this scenario, there are many different ways to handle these situations, but one way to handle this, which I think has worked very well, the situations I've been confronted with is what I call the gentle confrontation meeting. So in this circumstance, this would be definitely under advice of counsel because of it's very important how you word the message and the concerns to Cecilia during the meeting. But essentially, you choose two senior management folks that she has a good relationship with and a close relationship with and that she respects. And they meet with her and recount for her what they have observed and the concerns about the current client complaint. And the goal of the meeting is to obtain Cecilia's buy-in to reach out to her provider and consult with her provider about whether something's going on. In most situations where we've gone down this road, I've gone down this road with clients, it's been successful and the individual does go to the provider and the process essentially starts. It's a process-based approach, Americans with Disabilities Act approach that we've been talking about, but it starts with a different kind of meeting because of who Cecilia is, the nature of the observations, and the circumstances. So there are many different outcomes to these scenarios. After you've gone through, obtaining information from the provider, from Cecilia, information on what the problem is, if there is a problem, and what reasonable accommodation can be made. In one scenario, the outcome was that after a series of tests, the individual took a leave to have more tests done, an FMLA leave, ADA leave. And in the end, it turned out that she did have significant memory and other issues that could not be corrected and were causing her and continuing to cause her difficulty in performing her job. It was determined by her physician that she could no longer practice in her profession, and that ultimately ended up in retirement. In another scenario, the outcome was very different. It was determined that the individual actually had a chemical imbalance of some kind and a severe vitamin deficiency. So after the interactive process, the reasonable accommodation process, she was provided a leave, ultimately returned to work on a reduced schedule, and was able to resume her regular duties. In these kinds of scenarios where you have somebody, particularly if they've been with you for a long time, and they are starting to show some decline of some kind, there is always a tendency to want to reach out to family members, particularly if you have a close relationship with the employee and the family, etc. This is very risky and it's not advisable in most circumstances. There have been situations where, because of a significant health risk and safety risk, I have advised clients to reach out to a family member. But how this is done and what the family member is told needs to be carefully considered so as to not violate privacy concerns and create a bigger problem out of the situation. In this situation too, if the person does return to work, and there are reasonable accommodations that can be made to allow her to continue to perform the essential functions of her job. Do not forget about the performance issues. Those don't just go away. Just like with all the other scenarios, you've gotten your documentation in order, you've gotten your process in order from an Americans with Disabilities Act, Family and Medical Leave Act, etc. perspective. The other bubble you need to deal with are the performance issues, and we've talked through various ways to do that, meeting with the employee, documenting, follow through, so that in the end, you've got, again, decent documentation on your ADA interactive process and the accommodations you've made there and the actions you've taken there. But you also have, on a second path, decent documentation of performance concerns. Potential action items in this area, again, working through a number of these difficult scenarios often draws out policies that may need to be updated. Also in this aging workforce scenario in particular, if you are dealing with a job that has a job description, an accountant job typically wouldn't. But if you are dealing with a job that has a job description, you're likely to find during this process that the job description needs updating because there may be one or more essential functions of the job that you wish had been listed there, and the job description was unhelpful to you because they were not listed. Let me talk for a few minutes about the special case of pregnancy. So this is one of those areas where many, many interesting federal and state laws and local laws in some situations come into play. So in some situations, the employees, it's all very straightforward. The employee has no work restrictions and there are no work implications. The individual works until she has to be out on leave for the birth of her child. The leave is handled under the Family and Medical Leave Act. If that applies, there may be state law, depending on the state that you're in, that applies. Some of the state Family and Medical Leave Act runs concurrently with the federal law. In some states, it does not. If there is no federal or state law that applies to the particular employee, the employer has to offer the employee some kind of a leave upon the birth of a child, or they will risk pregnancy discrimination, sex discrimination, and other claims under federal and state law. In some scenarios, of course, as we probably have all experienced, we deal with pregnancy situations that are not so straightforward, where there are pre-birth complications, the need for leave, the need for work accommodations, etc. In the pregnancy area, it's important to make sure that you know whether there are state statutes addressing pregnancy accommodation. There are an increasing number of states that have such statutes. For instance, in Minnesota, just to give an example, we have a statute that allows for automatic accommodation for pregnant women in the workplace in terms of more frequent restroom breaks, food breaks, water breaks, seating, and limits on lifting over 20 pounds. They are entitled to these accommodations without documentation from a provider or a doula, etc. In other situations, there may not be a state law that specifically addresses the accommodation that's needed. So what do? You go through the same process-based approach that you would with employees that have other types of limitations, physical or mental limitations. You meet with the employee, you engage in that interactive process that with the employee and the provider that we spoke about. You take into consideration any FMLA, state law, ADA leave and accommodation. You make the appropriate documentation of what accommodations are being made, and you manage that situation. And as with every other situation, if there are performance issues, you document and handle those separately to make sure that you are not simply forgetting about performance issues for an individual who happens to be pregnant. One other point I wanted to make in the pregnancy area, folks may have heard of a decision of this U.S. Supreme Court. It came out in 2015, the Young versus United Parcel Service decision. There appears to be a lot of confusion about this decision and its implications. The decision involved a number of things, but in essence, it involved a situation where the employer provided light duty and other accommodations for work comp injuries and didn't provide accommodations for restrictions that folks had when pregnant. If you have any kind of a policy or practice of not providing pregnancy accommodation, even outside of a practice of providing accommodation for work-related injuries, etc., please reach out to your counsel because you are in high-risk category. Pregnancy discrimination cases and claims by pregnant workers are very much popular claims right now. So in conclusion, we do have evolving and difficult challenges with our workforce in this 21st century. However, even in the midst of these most difficult situations, there is always a path forward. There's always a path to resolution. We urge you to seek advice and assistance in mapping out an approach that's best designed to accomplish a resolution, particularly in these tricky areas and situations we've illustrated in this talk today. To be successful, as I hope the discussion points have demonstrated this afternoon, each of the paths necessarily involves active management and documentation and good communication with the employee and others in the process. It also, of course, involves, and it's difficult to tell folks this, I totally understand, but it also involves a good deal of patience sometimes, and even a bit of fairy dust, it seems. Thank you for your attention this afternoon, and please don't hesitate to reach out to me or to any member of our group if we can be of help in talking about accommodation strategies or other employment issues. I will now turn to questions. And just give me a moment. They're being handed to me now. Oh, this is an excellent question, of course. The individual asked, can you address the accommodation analysis in a hiring scenario rather than long-term employee scenario? Absolutely. We don't see a lot of legal claims coming out of the hiring scenarios. But I have had them over the years, and I've definitely advised many of my clients on accommodation issues that come out during the hiring process. I'm going to answer this question outside of the affirmative action process. It's not a different answer, but it's a more involved answer if you're talking about a federal contractor. But in essence, in fact, I'll talk about a scenario here. One of my clients does pre-employment testing, and their pre-employment testing is a basic testing regarding language ability that they have determined is a level of language ability that is needed from a safety perspective for their plant. And they also have, for some positions, some basic math tests because of the nature of the job. There are all sorts of requirements in order to put testing in place, but I'm going to leave those aside. I'll just to talk about the scenario. So they had an individual apply, and this employer, as is recommended for all employers on their online application, it indicates who to contact if the individual needs a reasonable accommodation in the hiring and application process. And this individual reached out to the Human Resources Department and indicated that he had a learning disability. So we followed that process-based approach, actually. The hiring manager, actually I believe it was the Human Resources Director, reached out to him, got some further information from him, explained to him that the company would need some further information from his treating provider. They worked with counsel to create the inquiries for the provider. The provider responded and indicated that the applicant needed more time for the test. And so after discussion, we decided that that was a reasonable accommodation and allowed the applicant to have more time for the test. So absolutely, at the hiring stage, you need to be concerned about and react to appropriately accommodation requests. I'm reading a question. Just give me a moment, please. Another excellent question. Can you speak to modifying performance expectations when an employee has special accommodations. For example, if a salesperson has a reduced work schedule, is it necessary to modify performance requirements? Excellent question. So if, for instance, in the mental health scenario that we talked about, the individual had to work a reduced work schedule for a period of time, absolutely we would have to adjust performance expectations to fit the number of hours that the individual could work. You can still, of course, and should hold people to performance expectations, but you have to adjust your expectations based on how many hours they are able to work in a day or in a week. Another question? When talking about the CPA example, you mentioned she also has separate ethical obligations. I was talking about professional ethical obligations. For instance, lawyers are held to ethical obligations and requirements for their licensing. I apologize for the confusions there. There are no other questions. I thank you very much for your attention, and thank you for participating today. I hope you have a good afternoon.